Hi, I'm Jeff McDonald with Yelena and Akim from the law offices of Hassett and George. We wanted to talk to you today about what we're seeing in our practice, which is a significant rise in arbitrations, whether it's the cost of elongated litigation or whether it's the overcrowding of dockets, which is causing cases to take a long time. We're seeing a lot of cases pre-suit or just before trial opting for arbitration. Some are referred to by the court and others are voluntary agreement of the parties. With that increase in arbitration, we're seeing superior courts determining how those arbitrations will have impacts on other subsequent proceedings.
The outcome of an arbitration can be used either offensively or defensively sometimes. There are certainly cases where a plaintiff will sue a tortfeasor, and rather than stake the outcome of a trial, the two will agree that they will do a binding arbitration. And after the arbitration, sometimes the plaintiff, if UIM coverage is available, will go on to sue a UIM carrier. And in that case, the UIM carrier very well may be able to use the outcome of the plaintiff's prior arbitration decision with the tortfeasor in order to defensively stop the plaintiff from obtaining any more benefits. And obviously that would be a very advantageous outcome to a lot of our insurance clients. In 2014, the legislature enacted 52-235F, and that statute says that if a court refers a case to arbitration, that the outcome actually can't be used either offensively or defensively by anyone. So you want to keep in mind that in deciding whether you want to try to go after and preserve or use the finding of a prior arbitration, that it must be one that the court didn't actually refer out. So from a defense standpoint, if we're defending a tortfeasor, we can say to the other attorney, come, let's get a court-appointed arbitration, court-referred, and if you find that the result isn't quite what you wanted, but you were able to exhaust coverage, you can still then, in a subsequent proceeding, go after the UIM carrier. So it can be helpful in terms of resolving an underlying suit when you're defending a tortfeasor.
Right, and that is absolutely one of the benefits to arbitration. And another scenario in which we're seeing arbitration have impact on subsequent proceedings are in cases where we've all had those files where it's two plaintiffs each claiming that the other party is responsible for the accident. Maybe they're each claiming they had a green light. In those scenarios, one plaintiff may want to arbitrate their case, but the other plaintiff doesn't. And if that plaintiff does arbitrate his or her case and the other plaintiff doesn't, that second plaintiff could be barred from bringing a claim later or pursuing their claim. Because if the arbitrator finds in favor of that first plaintiff, it would be finding that the second plaintiff was at fault, and that could stick with that second plaintiff, and that could bar them from bringing the claim. So that's something that we're always cognizant of, again, using it offensively or defensively. And we're seeing superior court cases where, in the scenario where the second plaintiff didn't arbitrate the case, there may be summary judgment available because there is no claim that that second plaintiff can pursue. So we're seeing those cases more and more when we're seeing this sort of rise in arbitration. So with the rise in arbitrations that we're seeing, we expect to continue to see more cases and arbitrate more cases. And if you would like to discuss that further or have any issues with respect to arbitrations, we'd be happy to talk about it, either Yelena or I, or you could visit our website.